verdict of the jury was June 17th of 2021. The motion that was received in handwritten format was purported to be signed by Mr. Kakavelos' wife, and it was by his own created power of attorney. First, the court wants to address that issue and indicate that the one-page letter/power of attorney was mailed to Chambers, received yesterday, dated 11/24/2021. First, it doesn't comply with the laws governing powers of attorney, and I cite to General Obligations Law, Article 5, Title 15. One, in that it's not signed by the defendant. Two, that it's not notarized. Three, that there are no witness signatures which acknowledge defendant signed it, attorney, or that he signed it in their presence. I would also indicate that it further does not comply with the General Obligations Law, in that the agent, which is his wife, her signature is not acknowledged, nor is it witnessed. The court would find, though, that even if it had been valid, or if the court were to find that it's valid, in the alternative, the defendant has assigned counsel who was appointed to represent him back in October, and any motions obviously must be filed by the defendant's attorney, not from the defendant himself. In addition, the 330 motion is improperly filed in that it's in not proper form. In addition to the improper signatures or the lack of signatures, it's not sworn to, it's not notarized. The claims within it are both conclusory and not supported by sworn factual allegations, and are not record-based. So court finds here that the allegations are conclusory and speculative, not based on personal knowledge as is required, and there is no substantiation of the essential facts in the affidavit. Further, a review of those claims, the court finds all can be raised on a direct appeal from the sentence and trial in this court. The defendant's letter application received on November 9, 2021 for assignment of new counsel to replace Mr. Sacco is denied. First, we had trial attorney Mr. O'Brien, who was retained by the defendant. Then we had the appointment of Mr. Sacco at the request of Mr. Kakavelos, who requested new counsel. The court accommodated his request and provided counsel for him. And in addition, I believe even prior to Mr. O'Brien, there were one or two counsel who represented the defendant. At the 11th hour request for new counsel is denied. The claim by the defendant that because Mr. Sacco has an office in Saratoga Springs and Gloversville does not present a conflict of interest despite the defendant's claim. There's no indication that this information was purposely withheld from the defendant and is baseless and frivolous, and so it is denied. All right. Now, turning to the issue of sentencing directly today, I do have both sides' sentencing memoranda, which I will file with the clerk of the court. Prior to filing with the clerk, Mr. Sacco, do you wish to add any additional oral argument today or anything else for the record, or are you satisfied to rely on the written material which you submitted?
Judge, just briefly, Your Honor, although I'm new to this case, obviously a very serious case, I want to point out some of the factors that I think shade in favor of my client, Mr. Kakavelos. He's never been in any kind of legal trouble. It's his first brush with the criminal justice system. He is a local business owner that's done well by all accounts, employed many people, and as we know, I believe from Mr. Kakavelos' testimony, his family is very dear to him, and he's been a good father to his 3 children and a good husband to his wife. So So based on that, Judge, he's a first-time offender. I would ask the court to sentence him to the minimum permitted by law. Thank you.
Thank you, Mr. Sacco. Mr. Prema, do you wish to supplement your written submission to the court by way of any oral remarks today?
I would, Your Honor, and I would like to read portions of that memorandum as well.
Sure, you certainly may do so.
Thank you, Your Honor. Despite what Georgios Kakavelos and James Duffy thought, and ultimately what they did, Ally's life mattered. In life, she was adored by her family and her friends. In death, she was mourned by an entire community. Ally wasn't rich, she wasn't famous, she was much more than that. She was genuine, she was generous, and she was courageous. At the age of 22, Ally earned her reputation as an extremely hard-working and assertive woman who was not afraid to stand up for what was right. She was the one who confronted the defendant about his fraudulent business practices on behalf of herself and her female co-workers. She did not want to see anyone in her life shortchanged. When the defendant failed to pay his workers on time, it was Ally who made sure that they were paid first, even if it meant that she would have to wait or go without her own pay. When I interviewed many of Ally's co-workers, they remembered in particular how Ally would yell, "Love ya," when they left the sub shop at the end of their shift. They knew Ally meant it. When Ally first began working at the local number 9 deli, she believed the defendant was just a strange and arrogant man. In time, she learned about her boss's penchant for dishonesty, but Ally never knew how truly diabolical the defendant was until the last moments of her life, which I will elaborate upon in just a few minutes. The defendant's pre-murder conduct. Although the defendant, as Mr. Sacco has said, did not have a criminal record prior to the present conviction, he had been engaging in fraudulent activities for over 2 decades in conjunction with the eateries that he owned and operated in Saratoga and Fulton counties. The proof at trial showed over that period of time the defendant underreported his employees' hours to the New York State Department of Labor, the New York State Department of Tax and Finance, and IRS. He failed to pay his employees on time and for the full amount owed to them. He never paid his employees overtime. He always paid them in cash without issuing pay stubs. He refused to pay unemployment insurance contributions, and he evaded his tax obligations. After the defendant was caught and fined twice, and after the defendant declared personal bankruptcy in 2019, he continued to engage in the same fraudulent business practices at the local 9 deli while accruing over $70,000 in tax debts to the New York State Department of Tax and Finance, $120,000 to the IRS, and tens of thousands of dollars in remuneration and fraud penalties to the New York State Department of Labor. Ally warned the defendant that if he did not stop his unlawful business practices, that she would turn him into the labor board and for tax fraud, and that she would expose him on social media. She hated the way the defendant treated her and her co-workers. Approximately 7 weeks before Ally was killed, she met with the New York State Department of Labor investigator and voiced her grievances. According to Duffy, co-defendant, when the defendant learned about this meeting, he became livid and focused all his anger on Ally, proclaiming Ally was the ringleader amongst the female workers and a bitch who was determined to ruin his business, his reputation, and his livelihood. The defendant decided the only way to permanently silence Ally was to kill her, as if she were just another item on his otherwise mundane to-do list. Initially, the defendant hired Duffy to act alone in killing Ally, to distance himself from the act and to frame Duffy if he had to. The 2 men contemplated different ways Duffy could kill Ally, including staging an accidental drug overdose or a botched robbery inside the deli. The defendant rejected these plans because news of a dead body inside the local 9 would only generate negative publicity for his business. It was all about business for the defendant. The 2 men agreed upon a plan whereby Duffy would strike Ally over the head with a baseball bat and stuff her body in a large Dame Marie sandwich prep cooler for them to hide and transport the body before disposal. On Sunday night, October 27, 2019, after Duffy could not go through with the killing, the defendant lambasted his partner for his cold feet by calling him a pussy and a bitch. The defendant decided he could not count on Duffy to act alone and needed to physically participate in the murder himself to ensure the intended result. On October 28, 2019, the day Ally was killed, the defendant purchased a set of clothes for himself at Walmart for the sole purpose of using them during the murder and disposing of the material and any trace evidence later. The defendant also bought work gloves to bury Lamont's body and 2 bags of fertilizer, which he believed would hasten its decomposition. All these acts were acts of premeditation. The murder itself. The finalized murder plan involved a ruse where the defendant, after closing time, would distract Ally with cleaning tasks in the deli washroom while Duffy came in and struck her with a bat from behind. The defendant was supposed to slip a contractor-grade garbage bag over Ally's head prior to the first bat strike to minimize the blood spatter. However, the plan did not go as expected. Duffy struck Ally in the head prior to the bag being placed. The defendant then pulled the bag over Ally's head after the initial blow and kept it there while Duffy inflicted 3 more blows using the bat to her skull. Despite her injuries, Ally continued to fight for her life. Even as she was knocked to the ground with the bag still over her head and the defendant straddling her and attempting to choke her, Ally fought on. Duffy's cold and graphic testimony described Ally's valiant struggle while Ally's arms covered in defensive wounds confirmed it. Unable to finish Ally off by choking or suffocating her, the defendant yelled to Duffy to get something heavier. Duffy returned with a 2.5-pound sledgehammer and struck Lamont in the head with everything he had. If that was not enough, the defendant struck Lamont 3 more times with the hammer. Duffy testified that at that time, while still straddling her, the defendant had an expression of happiness on his face, as if to say, "I got you now." Duffy remembered the defendant uttering something foreign, checking Ally's pulse and proclaiming, "It's over, she's dead, she's done." The defendant showed no mercy to Allyzibeth Lamont on October 28, 2019. And I know this court will take into full consideration that fact when imposing sentence upon this defendant. Post-murder conduct. As Ally's body lay lifeless on the deli floor, the defendant drove back to Walmart to purchase cleaning supplies for the larger-than-expected cleanup. At Walmart, the defendant took his time purchasing plastic sheeting, duct tape, towels, and bleach, and yet tried to convince the jury that he only had 15 minutes to get back to the deli or someone else was going to die. Who could forget the disturbing images of the defendant indulging in an Almond Joy candy bar after he committed such a grisly crime? Who could forget the callousness of the defendant purchasing a magazine minutes after ending Ally's life? Or the defendant remembering to buy laundry detergent for his wife just after killing the young woman he had the audacity to later claim was like a daughter to him. After the defendant returned from Walmart to meet Duffy at the deli, the 2 men finished wrapping Ally's body in plastic sheeting and duct tape, cleaned the washroom, and disguised the remainder of the bloody crime scene with red-colored soda syrup. They loaded Ally's body into the back of the defendant's Volkswagen Passat, along with several bags of debris utilized for the cleanup. Lamont's body and the bags were dumped beyond the woods line at the I-87 exit 13 southbound ramp in Malta. The next night, the men returned to that exit 13 scene with supplies. Ally's body was stripped completely and placed in a shallow hole with fertilizer, concrete blocks, concrete mix, and mud. The defendant claimed he had no part of this process, and yet his custom-made prescription glasses were found no further than 10 to 15 feet away from where Ally's body was buried. Over the next 2 days, numerous items of evidence, including the baseball bat, the shovel, parts, gloves, Ally's bloody clothing, wrappings, and used cleaning supplies, were discarded at Rollins Street in Milton, and some of the items were later moved to locations along Dean Lung Road in Galway. On October 31st, 2019, the defendant had the trunk of his Volkswagen Passat relined with material he purchased at the Lowe's store in Glenmont. Later that afternoon, he had the Passat detailed and deodorized at Hoffman's Car Wash in Colony to remove and destroy any remaining trace evidence from the car. Finally, on October 31st, 2019, after several breaks in the case, members of law enforcement were brought to the area near the I-87 exit 13 south on-ramp, where they unearthed and recovered Ally's body. The trial. On June 17th, 2021, after 6 weeks of trial that included over 60 witnesses, more than 700 exhibits, the jury announced it had a verdict while also making a remarkable request to the court in the midst of the COVID-19 pandemic. Instead of proclaiming the verdict from what had been the jurors' socially distanced assigned seats around this courtroom for the past month and a half, the jury then asked the court if they could assemble in the jury box for the first time and deliver their verdict standing together, standing united. The court granted the request, and the foreman declared that the jury had found the defendant guilty after each one of the 10 counts was read. Murder in the first degree, conspiracy in the second degree, 2 counts of concealment of a human corpse, and 6 counts of tampering with physical evidence. The jury had spoken. On October 28, 2019, evil was not monopolized by one person in this tragedy. There were 2 diabolical men responsible for intentionally causing the death of Ally that day. There was James Duffy, the brawn and muscle of the operation, who was serving an 18 to life sentence and who provided unabashedly cold and blunt testimony about killing Ally and about the type of person he is. Duffy, however, ultimately took responsibility for his actions. Georgios Kakavelos, on the other hand, was the so-called brains or mastermind of the operation of this premeditated murder, and he was a participant who appeared incapable of telling the truth at trial. He's a person who has not taken responsibility for his actions, and I assume never will. Because that is the essence of who he really is. A killer, a liar, and a master manipulator. With a note that when probation officer Danielle Nichols interviewed the defendant, she wrote this paragraph on page 15. Describing her encounter with the defendant. During his pre-sentence interview, the defendant remained emotionless and stoic. At no time did he ever refer to the victim by name. The absence of any type of remorse or regret was startling. Georgios Kakavelos never admitted any responsibility. He never said he was sorry. He never said he was wrong. His focus throughout the interview was entirely on himself. He bemoaned the injustice of what was being imposed upon him. The defendant blamed others for his current legal difficulties. He blamed his co-defendant, he blamed his legal counsel, and he blamed the criminal justice system. He refused to accept any responsibility. Throughout the interview, Georgios Kakavelos wrapped himself in a cloak of victim. Georgios Kakavelos always believes he is the smartest person in the room, but he couldn't outsmart law enforcement and a Saratoga County jury, a jury that ultimately rejected his absurd and grossly contrived testimony. Today we are asking the court to sentence the defendant to life imprisonment without the possibility of parole for the commission of murder in the first degree. I understand that this is an extraordinary sentence, but the extraordinary nature of this case calls for such a sentence. I have previously set forth in my memorandum my recommendation for maximum consecutive sentences with respect to the remaining counts. Since the murder in the first-degree statute was first enacted in 1974, no Saratoga County, to my knowledge, has ever convicted an individual of murder in the first degree until now. Such convictions have been reserved in New York State for only the worst of the worst type of criminals like Georgios Kakavelos. The brutality of the murder, this murder, cannot be understated. The images from the crime scene, Ally's bloody clothing, and the autopsy photographs cannot be ignored. Ally's life cannot be forgotten. Georgios Kakavelos orchestrated the grisly murder of Allyzibeth Lamont, and he needs to pay the maximum price allowable under New York State law, a sentence of life imprisonment without the possibility of parole. Thank you, Your Honor.
Thank you, Mr. Poremba. I do have the two sentencing memoranda, and I'm going to file both of those with the clerk of the court at this time. Let's turn to the pre-sentence investigation for a moment. Mr. Sacco, have you had a chance to review the entirety of the PSI, and if so, do you have any modifications? I will add, before I ask you that question, on page 1 where it indicates counsel, I have Mr. O'Brien as trial counsel, and I've added you, Mr. Sacco, as counsel at sentencing, just so the record is clear and the PSI is updated.
Okay, thank you, Judge.
Sure. Anything else besides that?
Judge, I'll rely on my sentencing memorandum. Essentially, as this document will follow my client, I've objected to certain hearsay statements that were included by the probation officer and the characterization that Mr. Poremba just went into, that he only cares for himself. And finally, Judge, I also put this in my sentencing memorandum that my client does wish to be housed in a facility closest to his family as possible to the extent the court can accommodate that. Other than that, Judge, after reviewing it with Mr. Kakavelos this morning, providing him with a copy, and reviewing it myself, I have no further objections.
Thank you, Mr. Sacco. Mr. Poremba, have you had a chance to review the PSI, and if so, do you have any modifications?
I have, Your Honor. And as far as modifications, I don't necessarily have any modifications. I just had a comment upon one of the defendant's quoted comments.
Yes.
You turn to page 11, Your Honor.
All right.
The second to last paragraph, or the penultimate paragraph.
Several times.
Where it starts with several times, but it goes into the defendant's statement. The defendant said, quote, "The truth never came out through the trial.
Yes.
I felt more that I was silenced to speak my mind to how things developed," end quote. I would like the sentencing minutes to reflect that this defendant testified in court for approximately 3 days, 3-4 days. He had the ability, he had the opportunity, and he took it to testify. To say that he was silenced during the course of the trial is a falsehood. He had the opportunity to testify, he took that opportunity, he was examined on direct for a day and a half, and then he was crossed for another day and a half. If the defendant's comments are more in reference to what his attorney did, I just want to state for the record that the defendant was asked several times before trial and during trial if he was satisfied with his attorney. He said yes. It was only until the verdict came back that he became dissatisfied with his original attorney. And that's the extent of my comment.
All right. Thank you, Mr. Poremba. And the record should reflect that at the conclusion of today's sentencing, I will file the modified pre-sentence investigative report with the clerk of the court. All right. Prior to Mr. Poremba hearing from victims, family members in the case, I do want to note for the record that we did receive in chambers a letter from the Commissioner of the Department of Labor, Roberta Reardon, which was dated June 15th of 2021 regarding Mr. Kakavelos' case. I think it's prudent to for the record to cite in part a portion of the letter, in that it's, I think, remarkable that the Department of Labor Commissioner took the time to write to the court to weigh in on the case as it relates to the department. First, Commissioner Reardon writes, "I extend my deepest sympathy to the Lamont family. I cannot fathom the suffering they have endured from this horrific and senseless tragedy inflicted by a calculated murderer." It goes on in part to read as follows. Allyzibeth came forward in good faith to report labor law violations to the Department of Labor to fight for justice for herself and her colleagues, and became the victim of the most heinous act of retaliation against a worker that the New York State Department of Labor has ever seen. I ask the court to consider the potential chilling effect in terms of sentencing that this murderer's actions will have on workers who seek to exercise a basic and fundamental right, the right to report mistreatment and violations of the law. Workers in New York State must be able to report labor law violations without fear of retaliation. This was a brutal and calculated crime, and the court has the power to set a precedent and to send a powerful message to dissuade any employer from ever acting in such an extreme and heinous manner. I implore the court to consider the unknown, unsung workers who suffer in silence, fearful of retaliation by their employers as a result of this murderer's conduct. Allyzibeth is a hero to the workers she fought to protect, and while nothing can bring her back, you can honor her legacy by making sure she did not die in vain. I provided that to both sides, and I'm going to file that with the clerk of the court. Mr. Premba, do you wish to be heard, or do any family members wish to be heard prior to the imposition of sentence today?
Yes, Your Honor. Brooke Lamont would like to speak. She is the youngest sister of Allie Lamont.
All right, thank you. Yeah, since we have the screens down, I'm going to ask that you keep either your mask on or that you wear a face shield. Either of you, you're good as you are? Okay, sure. And take your time. You have as much time as you need. If you need a break, just let me know, okay?
The day that you took my sister's life, you took a part of mine. Allie was the light of the room, the contagious smile, the laugh you could never forget. She would help anybody unless you gave her a reason not to. She was strong, caring, loving, and hardworking, and you took that all away. You robbed her of the chance to be able to get married, have children, or simply be an aunt to her nieces and nephews. You tried to silence her forever, but whether she's here or gone, she will always be remembered. Her memory will live on forever. You have no regard for human life. You disgust me and you make me physically sick. The truth is heartbreaking, something I will truly never forget. But now everybody knows who you truly are. A woman-hating, narcissistic piece of shit who lies to get his own way, even if it's his life. The pain and torment we go through as a family still, I will not forget that. You deserve the absolute worst. She wasn't a nobody like you thought. She has an army of family and friends who cherished her for who she was. The day you took her life, you took my best friend away from me. My sister, the person I grew up doing almost everything with my whole life. You put us and all these people through a trial for you to try and convince us that you didn't commit this heinous act. I hope her memory haunts you. I hope your guilt eats you alive. You'll never understand the pain that my family feels. We're changed as a unit and as people. We will forever never be the same. We grieve the loss of Allie every single day, for now and forever. And Allie, if you can hear me, I love you always and forever, and I hope justice is served. I'll see you again someday, just not in this lifetime.
Thank you very much, and I appreciate your taking the time to come into court today.
Thank you.
Anyone else who wishes to speak at this time?
The next speaker will be Tammy Quackenbush.
All right, thank you.
She's on hand.
Tammy Quackenbush. Good afternoon. Take your time, take a breath, and you have as much time as you need, okay? And if you need a break, let me know.
My name is Tammy. To Allie, I was Aunt Tammy. I will never get to hear her call me that ever again. I will never ever hear her say I love you. All because of you and your greed. I decided to write this statement for a step in our family's healing. You have shown no remorse this whole time, so I don't expect any now. You just need to know how you destroyed our family by your actions. Allie was a beautiful woman who had her whole life ahead of her, a life we will never get to see. We will never see her get married, have kids, or even have a life. She could have done anything. We will never understand why you did this, why you took it upon yourself to change our lives forever. To us, Allie will always be 22. We only have 22 years of memories of her. We are so thankful for them years to love her and cherish her, and we will hold them memories in our hearts forever. I hope that you never get a moment's peace ever again for what you did. Your Honor, we ask that you sentence him to the same thing he sentenced us to, life without parole. Thank you.
Thank you very much. Mr. Trump, anyone further?
The next speaker will be Krista Lamont, mother of Allie Lamont.
Okay. Krista Lamont. Good afternoon.
Good afternoon.
Take your time and take a breath, and you have as much time as you need, okay?
I'm Allyzibeth Lamont's mother. I and her father will always be forever devastated and enraged by the fact that when our daughter was fighting for her life and took her last breath, you were with her. Not someone who cared about her or loved her, but you who cares more about a bread recipe than a human being. You are a failure as a businessman. You're a failure as a human being. And you failed to get rid of our daughter because she's with our family, our friends, and everyone who knew her. Above all else, till the day you die, she will be in your head. You killed our daughter because you owed her money, and she stuck up for herself, and others that you owed. She wouldn't be quiet. For the rest of our lives, we will not be quiet. We will keep speaking about Allyzibeth and the horrific act that you committed to make sure you never have the opportunity to do this to another human being again. That's all I got.
Thank you very much for coming in today. Mr. Trump, anyone further?
Next will be Ashley Kitts. She's a crime victim specialist with our office. She will be reading two statements. The first statement that she'll be reading is a statement written by Sherman Lamont, father of Allie Lamont.
All right.
And the second statement she'll read is from Carly Sudges, who is the eldest sister of Allie Lamont.
All right. Ms. Kitts, good afternoon.
Judge?
You may proceed whenever you're ready.
You talked about a monster in the deli, and if that's true, which it was, there was also a devil in the same room. One being Jimmy, the monster, the other being the devil, you, Georgie. You took away one of the most precious things in this world to me. Allie was a girl with the biggest heart I've ever seen, and I've been around for some time. You had other choices, but she had none. Had Allie known your plan, she would be here today, or had you had a kinder plan, Allie would be here today. But you stood by your decision, so will I stand behind mine. I hope and pray that you die alone and scared. With that said, we all have a hero, and mine was and will forever be Allyzibeth Ann Lamont, because I truly believe if it wasn't her that you killed, it would have been someone else's baby girl. I hope you rot in hell, Georgie. A piece of my heart is gone because of you, George. I am Carly, firstborn daughter of Krista and Sherman, oldest sister of Llewellyn, Elizabeth, and Brooke. If only you were able to feel how hard the lump building in my throat feels, how it's even harder to swallow as I write it. Imagine how hard the tears would be flowing out of my control if I were to speak it. The burning ache strikes deep in my chest each and every single day, knowing that she was taken so early, so brutally, involuntary from this world. From a crinkly nose and 10 little toes to a blossomed soul at only 22. I watched as Allie grew. At only 22, her life was just starting. She was finally just getting her life together as a young adult for herself. She worked herself to death, literally, to try to achieve her personal and lifelong goals. Her half-crooked smile would light an entire world full of darkness. Her hugs would melt away all pain and worries in that moment. Allie would literally give the shirt off her back just to see someone else smile, feel comfort, to be noticed, to be thought of as a human. Allie was a goddess of beauty and love, walking in a world full of ugliness and chaos. Her laugh was contagious enough to soothe anyone that might need it, and she meant what she said, even when she would sing her heart out off-key. Allie was true to herself and people in her life. She didn't sugarcoat anything, and she stood up for what was right. Allie was a damn hard worker, working countless hours throughout the week, with and without others, making the most delicious food for others to enjoy. Nobody could compare to her when it came to making a sup. Hers were the best, and now I cringe at the thought of eating them sometimes. A pit sinks deep in my stomach. My heart stops for a second, followed by a rapid heartbeat that's as loud as my head. I feel like I could puke. For over a year, I wasn't, and still to this day, sometimes I'm not able to watch the news or read certain papers and articles because of the constant reminders that my sissy is gone in such a disturbing manner nonetheless. Certain scents will bring me to tears, as do certain songs or anything that bring back memories. Something so simple as a sub or watching the everyday news or remembering a time when she was alive now triggers me. Riding past where she was brutally murdered sickens me to no end. I get severely depressed, physically sick, emotionally unstable. I carry a plethora of roller coaster emotions that I wouldn't ever wish upon anybody. They're unpredictable and uncontrollable, hard to decipher and process. And honestly, the weight of them only intensifies as time passes on. I miss my sister day in and day out. I talk to her sometimes when I'm alone, in hopes that she can hear my voice. I dream of her, and it feels so real for a moment. I feel happy and whole again. Then I wake up, and I'm so angry that it's only a dream, and I can't shake that frustration until I'm able to sleep again. I don't trust very many people, and I constantly overthink every situation now. I used to be such a bright, bubbly, talkative, happy-go-lucky person. Now I walk around with such a dull, introverted, couldn't-care-less attitude. My spark is gone. It's hard to come to terms that nothing will ever be the same. My family is so broken, in our hearts, our minds, and our relationships with one another. I myself am forever changed. A piece of my heart will always be broken for what she had to endure, but seeping through those cracks will be the endless love and care and support that she gave me in her short life. You may have taken her physically, but she will always be alive in the hearts, minds, memories, and kind words of those that knew her, met her, or had a place in her life. I will never understand why you did what you did, but that is for you to sit and think about. I will never forgive you. I hope you can finally rest, Allie. I love you. We love you, always and forever.
Thank you, Ms. Kitts. All right, the record should reflect that I do have a letter dated October 4, 2021 from Ms. Kitts, which contains the written statements of Sherman Lamont, father, Krista Lamont, Brooke Lamont, sister, Tammy Quackenbush, aunt, and Carly Sudges as sister, Krista mother, obviously. I'm going to file those at this time. All right, Mr. Premba, do you wish to be heard any further prior to the court's imposition of sentence?
Nothing further, Your Honor.
Thank you. Mr. Sacco, do you wish to be heard prior to the court imposing sentence?
Your Honor, I have nothing further, and I know the court's going to inquire of my client. We've been discussing this for a while now, and again, twice today. And since he's going to appeal his conviction, he's, I believe, not going to make any statements.
Certainly that is within his right, but I will make an inquiry nevertheless. Nothing further from you, though, just to be sure.
No, Your Honor.
Okay, very good. Thank you. Mr. Kakavelos, the law gives you an opportunity to speak just prior to the imposition of sentence. This would be that time. You don't have to speak if you don't want to. It's entirely up to you. Do you wish to say anything at this time?
I will reserve my right, Your Honor, for a later date.
Thank you, sir. The court does have the statutory prerequisites to impose sentence. And first, with regard to its review of the PSI, the court takes exception to the defendant's claim that he had no opportunity to say why he did what he did and that he was not able to speak freely in court. Mr. Poremba addressed this issue during his remarks, but I think it's worth underscoring that the defendant testified for what is nearly 3 days of testimony in front of the jurors and in front of the jury, and had as much time as he wanted to. I recall the defendant testifying relatively in the narrative to tell his story, and there was no limitation on how much time he had. Obviously, there was cross-examination and there was further redirect, and so the court takes exception with his claim that he was not able to provide to the jury his version of the events. I think it's also worth mentioning, because it is rather extraordinary, that we have a number of the trial jurors sitting here in the courtroom today who appeared taking time out of their own day, out of their work day, out of their social life, their families. They spent 6 weeks in this courtroom working hard every day, and I think it's worth mentioning so the record reflects the interest, attention, and dedication that our jurors have in cases of this nature. I would also note that the defendant claims in his PSI that he had no discovery or that it was incomplete discovery, and the court takes issue with that as well. In fact, the defendant did receive full and complete discovery, and in fact the court accepted the people's certification of compliance with regard to discovery, and there was no challenge to the certificate of compliance and statement of readiness, nor were there any claims by the attorney that there was any material missing or unaccounted for. If there had been, certainly it would have been incumbent to raise that, but that was not an issue. I would like to address just briefly the victims who spoke today and whose statements also were read. I think it goes without saying that statements from victims are extraordinarily helpful. I can't imagine, having sat on this bench and been involved in the criminal justice system for nearly 35 years, how difficult it must be for a victim in any crime, especially a murder, to be present in a courtroom, to be in the same room as the person who committed the crime of murder against your loved one. I'm not sure I could have gotten up here myself, and I applaud you for your bravery, your tenacity, your dedication, and your commitment to her life, for being here today and for telling us all, not only just for Mr. Kakavelos, but for other courts, including this court, and all the people, including the jurors, how this crime impacted you. And so as difficult as that was for you to get up here to talk about it, I can't tell you how appreciative I am to hear it, because it does make a difference, and it will have an impact on the sentencing. There is a statement in the victim impact, there is a statement from one of the portions of the pre-sentence investigation that is quoted as, "Who goes to work thinking your boss is going to kill you?" All that Allyzibeth Lamont wanted was to get a paycheck and not be paid under the table. How twisted and exceedingly evil Mr. Kakavelos is for taking what would ordinarily be a very simple administrative act and pay her like she wanted to be paid, taking out her FICA and her taxes so that she could be a law-abiding, hard-working member of our community. And at 21, how noble of her to understand that this is an important part of being a working citizen in our community and being on the record of the Department of Labor. And the court finds that the defendant is so callous, so greedy, and so self-centered that instead of legitimizing Ms. Lamont's employment and simply giving her a payroll check, he decides in a very diabolical, conspiratorial way to kill her. And the proof showed that she died of severe skull fractures and brain damage. There is a portion also of the PSI in the evaluative analysis that he believes, Mr. Kakavelos believes, she stood in the way of his plans to open a new restaurant in Saratoga Springs, hoping to avoid an investigation by the New York State Labor Department. He considered several options for eliminating 22-year-old Allyzibeth Lamont. Kakavelos and his co-defendant James Duffy initially considered shooting Ally with a pistol, paying money for her silence, and giving her a drug overdose. Finally, after weighing all the options, they made the choice to kill her by beating her to death with a baseball bat and sledgehammer. Motive, intent, pre-planning, conspiracy, and greed were all proven by the prosecution and in front of the jury, and they believed, not only believed that theory of the case, but also embraced it by rendering a unanimous verdict of guilty. The defendant is guilty of these most horrid crimes. He placed his own self-interest above all else. The court finds his conduct is so contrary to the laws and norms of our society and our community that a lengthy period of incarceration needs to be imposed in order for justice to be served. It is with that the court imposes the following sentence. With regard, first, going backwards, the 11th count, tampering with physical evidence, Town of Colony, that's the detailing of the car, the maximum sentence of 1 1/3 to 4 years in state prison. With regard to the 10th count, tampering with physical evidence, Town of Glenmont, County of Albany, relining of the facade, 1 1/3 to 4 years in state prison. With regard to tampering with physical evidence, the 9th count, Town of Milton, County of Saratoga near Rowland Street, the court imposes an indeterminate term in the state correctional facility of from 1 1/3 to 4 years in prison. With regard to the 8th count, tampering with physical evidence, Town of Galway, County of Saratoga, near Dean Long Road, the contents of the garbage bag, the court imposes a sentence of 1 1/3 to 4 years in a state correctional facility. With regard to the 7th count, tampering with physical evidence, Town of Galway, County of Saratoga, near Dean Long Road, which relates to the baseball bat, the court imposes an indeterminate term in a state correctional facility of from 1 1/3 to 4 years in prison. With regard to the 6th count, tampering with physical evidence, City of Johnstown, County of Fulton, the Local 9 deli, which is for his conduct inside the deli, the maximum term of 1 1/3 to 4 years in a state correctional facility. With regard to the 5th count, concealment of a human corpse, Town of Malta, Saratoga County, that's for the cloverleaf burial, the maximum sentence of 1 1/3 to 4 years in a state correctional facility. With regard to the 4th count, concealment of a human corpse, Fulton County to Saratoga County, the maximum sentence of 1 1/3 to 4 years in a state correctional facility. With regard to the third count, conspiracy in the second degree, the Class B felony, the court imposes the maximum sentence permitted by law, 8 1/3 years to 25 years as an indeterminate term in a state correctional facility. The second count of the indictment is a lesser included section. The first count, murder in the first degree, the court imposes the maximum sentence of the defendant's natural life without parole as the sentence of the court as relates to count 1. It is further the order of the court that the sentences imposed by this court all run concurrently except count 5, which is the concealment of human corpse, the cloverleaf burial, where the defendant crushed the body, poured in lime, concrete, and buried her in a shallow grave, wrapped in plastic. The court will order that that indeterminate term of 1 1/3 to 4 years shall run consecutively, meaning after the life sentence is completed. In addition, the court also imposes the statutory surcharge of $375, as well as an order to provide a DNA sample. I will sign the DNA order and provide an order converting the surcharge into a civil judgment if it's not paid within the next 60 days. I'll give you a minute to go over those charges. And so the record is clear. I want to make sure that with regard to count 1, that is murder in the first degree, if the record is unclear, for the life without parole sentence. All right, the record to reflect those documents have been returned to the clerk of the court. I am filing the original pre-sentence investigation, signing the DNA order, filing that with the clerk of the court. Lastly, Mr. Kakavelos, I do advise you, if you feel you've been subjected to any illegality or injustice during this proceeding or any prior proceeding, you must, within 30 days of today's date, file a notice of appeal upon the Saratoga County District Attorney's Office and the Saratoga County Clerk. Mr. Sacco, anything further today?
No, Judge, thank you.
Thank you, sir. Mr. Premba, anything further?
No, thank you, Your Honor.
All right, thank you. I remand Mr. Kakavelos into the custody of the Saratoga County Sheriff's Department to commence his sentence. That'll conclude the matter. Thank you all. Recess to chamber.
All right. What's that?